Welcome back, everyone, and to those who are new, welcome for the first time. I know it's been a while since my last upload, but as you already know, the life of an attorney can get pretty chaotic. Today, we're diving back into civil procedure, focusing on a pleading that's essential to understand, the plea. It's crucial to note that there's a distinction between a special plea and a regular plea, and only the plea will be covered in this episode. Counterclaims will also only be discussed in a future episode. Before we dive in, please consider sharing this channel with your friends and colleagues, and don't forget to hit that subscribe button. You can also connect with us on Facebook and Twitter. Additionally, comprehensive notes are available for download on Stuvia. These notes come with a small fee to help support the growth of this channel. Everything else, of course, remains absolutely free. Alright, let's get into it. What is a plea? A plea is the defendant's formal written response to the allegations set forth by the plaintiff in its particulars of claim or declaration, depending on the type of summons issued. It serves as a statement wherein the defendant outlines its position and defense insofar as the plaintiff's allegations are concerned. Essentially, in a plea, the defendant provides clear and specific answers to the allegations made by the plaintiff. Simple, right? When must a plea be delivered? Well, answering this question is as simple as referring to the relevant court rules. Think of them as your legal Bible. Knowing them inside out is key. Uniform Rule 22 subsection 1 and Magistrates Court Rule 17 subsection 1 provide that, where a defendant has delivered notice of intention to defend, he shall within 20 days after the service upon him of a declaration, or within 20 days after delivery of such notice in respect of a combined summons, deliver a plea with or without a counterclaim in reconvention, or an exception with or without application to strike out. Before we continue, let's break down what these rules mean from a procedural standpoint. First off, for purposes of this episode, there are two types of summonses, a simple summons and a combined summons. Within 10 court days of being served with the summons, the defendant can deliver a notice of intention to defend if they intend on contesting the action. Keep in mind, deliver means both serving and filing. Importantly, delivering a notice of intention to defend must come before delivering a plea. Without defending the matter, a defendant cannot deliver a plea. If the defendant delivers a notice of intention to defend after receiving a simple summons, the plaintiff then has 15 court days to deliver their declaration. Think of it as the equivalent of a particulars of claim. For combined summons, the particulars are attached to the summons. If this still confuses you, check out our previous episodes on summons. They'll clear things up. Now, within 20 court days of either receiving the declaration for the simple summons or delivering the notice of intention to defend for the combined summons, the defendant has four options. They can deliver a plea, addressing all the plaintiff's allegations in their particulars of claim. They can deliver a special plea alongside a plea. A special plea raises a unique defense that doesn't stem from the plaintiff's claims. They can deliver a plea and or a special plea with a counterclaim. They can deliver an exception. This happens when a pleading is vague and embarrassing or lacks the averments necessary to sustain a cause of action or defense. Today, we're focusing solely on the plea. Special pleas, counterclaims, and exceptions will be explored in future episodes. One last point to note. If the plea isn't delivered within the specified time frame, the plaintiff can deliver a notice of bar. This grants the defendant an additional 5 court days to deliver their plea. Fail to do so and they're automatically barred. In that case, the plaintiff can proceed with default judgments. What must be included in a plea? Now that we have a handle on what a plea is and when it should be delivered, let's delve into the actual content of a plea. Time to refer to our trusty rules once more. Uniform Rule 22 subsection 2 and Magistrates Court Rule 17 subsection 2 lay it out for us. The defendant shall, in his plea, either admit or deny or confess and avoid all the material facts alleged in the combined summons or declaration, or state which of the said facts are not admitted and to what extent, and shall clearly and concisely state all material facts upon which he relies. The rules go on to state that every allegation of fact in the combined summons or declaration, which is not stated in the plea to be denied or to be not admitted, shall be deemed to be admitted. If any explanation or qualification of any denial is necessary, it shall be stated in the plea. These rules essentially provide that in response to each allegation of fact made by the plaintiff in their particulars of claim or declaration, the defendant may admit the allegation, deny the allegation, not admit the allegation, confess and avoid the allegation. Where a fact or allegation is not admitted, the defendant must also specify the extent to which it is not admitted and state the material facts upon which it relies. An allegation of fact is a statement of claimed fact contained in the particulars of claim or declaration. For example, the defendant breached the agreement by failing to make payment on due date. Admitted allegations. As an example, let's say that at paragraph 2 of the particulars of claim or declaration, the plaintiff alleges that the defendant is Joe Soap, ID number, whatever, a major male businessman whose full and further particulars are to the plaintiff unknown, with his residential address at 8 North Road, Morningside, blah, 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 and employment address at Highfield Systems, blah, blah, blah. According to the defendant, the contents of this paragraph are true and accurate, and as such, he wishes to admit same. Where an allegation of fact is admitted, the defendant may phrase his admission in any of the following ways. The allegations contained in this paragraph are admitted. The contents of this paragraph are admitted. The defendant admits the contents of this paragraph. The specific wording of an admission is not strictly prescribed, but be advised that if it is unclear whether an allegation is admitted or denied, it is deemed to have been admitted. Furthermore, if an allegation is not addressed, it is deemed to have been admitted. Although I will cover this in more detail shortly, note that the defendant will first insert add paragraph 2 in the plea, followed by the admission of the allegation of fact. The add paragraph headings will be inserted throughout the plea. Admitted allegations do not need to be proven or disproven at trial, summary judgment, or any other stage of the proceedings. Let's now have a look at allegations which the defendant denies. Let's say that at paragraph 10 of his particulars of claim or declaration, the plaintiff alleges that the defendant failed and or refused to attend to the premises on the agreed upon date to commence construction of the fence. According to the defendant, he did attend the premises on the agreed upon date, but the plaintiff was nowhere to be found. As such, the defendant will deny this allegation. If an allegation is denied, the defendant may phrase the denial similarly to an admission. The contents of this paragraph are denied. The defendant denies the allegations contained herein. Those are just two examples. Where an allegation is denied, it is placed in issue, and the plaintiff is required to prove the allegation by adducing evidence. However, a mere denial is mostly insufficient, as the defendant should outline the factual basis of their defense or provide additional context. A plea amounts to a bare denial when the defendant fails to clearly state the material facts supporting their defense or lacks specificity, hindering the plaintiff's ability to respond effectively. In typical circumstances, bare denials may result in the plaintiff obtaining the relief sought in their claim. They must therefore be avoided. Additionally, under Uniform Rule 18 subsection 5 and Magistrates Court Rule 6 subsection 5, a party must not evasively deny an allegation, but address its substance directly in their response. Failure to unambiguously deny a fact could be construed as an admission. Hence, any ambiguity in denial may be interpreted as an admission of the alleged fact. Let's consider paragraph 2 of the plaintiff's particulars of claim or declaration again. Let's say every bit of the defendant's details are incorrect. Instead of pleading the contents of this paragraph are denied, rather state that the contents of this paragraph are denied and the plaintiff is put to the proof thereof. In particular, the defendant's name, ID number, residential, and employment address are incorrect. It may happen that the plaintiff's particulars of claim or declaration contains an allegation of fact which encompasses 2 or 3 allegations. For example, the plaintiff pleads in a paragraph that on 24 May 2023, the defendant intentionally stabbed the plaintiff in the leg with a dagger. Looking at this allegation, there are actually several averments made. These include the incident occurred on 24 May 2023, that the defendant acted intentionally, that the defendant stabbed the plaintiff, that the plaintiff was stabbed in the leg, that a dagger was used. It is obvious that if only 2 of the 5 averments are true, according to the defendant, he cannot simply admit or deny the contents of the paragraph. Instead, the defendant must isolate each allegation and address them separately. If, however, the defendant wishes to deny each of the averments made in the allegation, let's say he was not even with the plaintiff on 24 May 2023, he can deny the whole paragraph on lines similar to the following. The defendant denies each and every allegation contained in this paragraph as if specifically traversed. As already mentioned, however, to avoid a bare denial, the defendant should provide the basis upon which his denial is based. What is a non-admission? It has been held that there is a clear distinction between denying an allegation and not admitting it. A plea of non-admission is generally appropriate when the defendant does not have knowledge of the allegation. A statement that the defendant does not admit a fact is not considered a denial. A non-admission could be pleaded as follows. The defendant has no knowledge of, insert the averment, and puts the plaintiff to the proof thereof. As the defendant has no knowledge of the averment, he cannot now try and contradict the plaintiff's version. What is confession and avoidance? A plea in confession and avoidance essentially arises where the defendant raises a specific defense, such as fraud on part of the plaintiff, waiver by the plaintiff, payment or settlement by the defendant of his obligations, or one of the parties is acting ultra vires. This type of plea is so termed because the defendant admits the substantial facts upon which the plaintiff relies, but also wishes to avoid the resulting legal consequences of such confession by raising additional facts which, if proved, will defeat the plaintiff's claim. In such a case, High Court Rule 22 subsection 2 and Magistrates Court Rule 17 subsection 2 apply, and the defendant is therefore required to set out all material facts relied upon. A plea of tender is essentially one of confession and avoidance and must be specifically pleaded. Multiple and alternative defenses. Where the defendant wishes to raise more than one defense against the plaintiff's particulars of claim, each separate defense must be pleaded. If two defenses are mutually destructive, the defendant cannot rely on both at the same time. In other words, only one or the other, and not both, can succeed. In such a case, the defenses must be raised in the alternative. Additionally, since the plea is a type of pleading, Uniform Rule 18 and Magistrates Court Rule 6 also apply. According to these rules, the title of the action describing the parties thereto and the number assigned thereto by the registrar shall appear at the head of each pleading, provided that where the parties are numerous or the title lengthy and abbreviation is reasonably possible, it shall be so abbreviated. Every pleading shall contain a clear and concise statement of the material facts upon which the pleader relies for his claim, defense, or answer to any pleading, as the case may be, with sufficient particularity to enable the opposite party to reply thereto. When in any pleading a party denies an allegation of fact in the previous pleading of the opposite party, he shall not do so evasively, but shall answer the point of substance. A party who in his pleading relies upon a contract shall state whether the contract is written or oral, and when, where, and by whom it was concluded. And if the contract is written, a true copy thereof, or of the part relied on in the pleading, shall be annexed to the pleading. Structure of a plea on the merits. The plaintiff's particulars or declaration is divided into consecutively numbered paragraphs. Each paragraph contains one or more allegation of fact which makes up the cause of action. The defendant's plea must be drafted in such a manner that each allegation contained in the paragraphs is specifically addressed. The plea is designed so that every allegation is addressed using the format add paragraph X. So, to simplify, in a plea, start by including the party's details and the case number from the summons. Next, either admit, deny, or confess and avoid each material fact in the particulars of claim or declaration. Specify which facts you don't admit and to what extent, and outline the material facts on which your defense relies. It may seem complex, but don't worry, it becomes clearer as we start drafting the actual plea. What are the other rules governing the plea? There are several additional, more general rules that apply to the plea. Rather than providing an exhaustive list of these rules verbatim, I will provide a summary of their key points. Both an advocate and an attorney must sign the plea. In the case of an attorney with the right of appearance, only the attorney's signature is required. If a party is representing themselves, that party should sign the plea. The plea should be organized into paragraphs, including subparagraphs, each consecutively numbered. Each paragraph should present a distinct averment to the extent possible. The plea should offer a clear and concise statement of the material facts on which the defendant relies for their defense or response to the summons or declaration. This statement should be sufficiently detailed to enable the plaintiff to respond effectively. When denying an allegation of fact made in the summons or declaration, the defendant should provide a substantive response rather than an evasive one. The plea is not required to explicitly state the circumstances from which an implied term is inferred. Failure to comply with any of the above rules renders the plea irregular. In such cases, the plaintiff is entitled to take action in accordance with Rule 30. In the next episode, we'll be drafting a plea, so keep a lookout. Please remember to subscribe and share this video with your friends. Thank you.